Good evening. I'd like to call the Monday, January 5, 2026 meeting of the Park Township Zoning Board of Appeals to order. Chairperson Felice is excused. His absence is excused with prior approval, and we do have a quorum present. At this time, we are moving on to item number 2 on our agenda, approval of the agenda. Are there any changes or corrections to the agenda?
Motion to approve.
We have a motion and support to approve the agenda. All in favor? All opposed? Okay, motion carries. Next item of business is approval of the minutes from the December 1, 2025 meeting of the Park Township Zoning Board of Appeals. I've reviewed the draft minutes and I would request one correction on page 3 of the minutes. Near the bottom of the page, it has the, in bold, motion made by Morgan. After that sentence, it goes on to say conditions for approval include that residential use of the structure is not permitted, and then it goes on. I would ask for a correction of the word residential, I believe should be dwelling, or insert the word dwelling, because this is a residential garage, but I think the discussion in the motion was to preclude any dwelling usage. Are there any other comments, corrections regarding the draft minutes?
Support.
Okay, we have a motion and support to approve the minutes from the December 1, 2025 meeting. Any discussion? All in favor?
Aye.
Opposed? Okay, the motion carries. Next item on our agenda is a public hearing on an application by Interlake Properties LLC for an appeal of a decision of the zoning administrator regarding the status of the subject parcel as an unimproved lot per section 38-66 sub 1 of the Park Township Code of Ordinances. Said land and premises are located on the north side of Interlake Walk, east of Lakeside Road. Address unassigned, parcel number 70-15-33-382-021, and in the R4 medium density single and two-family residence district, and also the Macatawa Park overlay district. I would ask staff to introduce this item to the board, and then we'll follow that with a presentation by the applicant.
There's not much more to add to this. It is a unique parcel in Macatawa Park overlay district. It is almost completely landlocked. There is a 5-foot wide access easement that was platted with the I think it was the 1923 or 35, sorry, 1935 was re-subdivided. It is present in that re-subdivision.
Okay, thank you. And as I understand it, we have in front of us a Park Township Zoning Board of Appeals application filed November 21, 2025. Applicant Interlake Properties LLC. There are 3 items or 3 requests on that application. Number 1 being a dimensional variance. The second item checked being an appeal of a decision of the zoning administrator. And number 3 being other requests. Tonight, the ZBA's sole issue before it is the appeal of the decision of the zoning administrator. Is that correct?
Yes.
Okay. So we do have some items in our packet that are probably more appropriately addressed to the other items, but those have been received. I would also note for the record that we did receive some email correspondence regarding this application, 3 emails. And those will be included in the record as it pertains to this application as well. Is the applicant or someone on behalf of the applicant present?
Yes, good evening. Carl Gabriels on behalf of the applicant. And it is my understanding as well that the discussion tonight would be limited to simply one of the points in what we filed. That was direction from the zoning administrator, and we certainly will honor that and just stick with the one issue. I didn't know if there was an intention. We don't have a problem with waiting for Ms. Handel to appear if that's what the board would prefer.
I think that since you're offering that, and I think that makes sense since she does intend to be here, that she has the benefit of hearing your presentation as well. I would ask that you go ahead and sign in if you haven't done so already on the sign-up sheet at the podium. We can obviously see who you are on the screen in front of us, not your application, but just for the record, if you could fill out that form, please. And you're welcome to take a seat until she arrives. Thank you. we took a brief pause. The applicant is here and has a presentation and offered to wait until you wanted to begin that. So with that, let's go ahead and turn it back over to the applicant.
Thank you. Good evening again. Carl Gabriels on behalf of the owner and applicant. Christian Fritz and his father Stephen Fritz are also here this evening. And they're seeking to build a home on lot 52 of the Macatawas Park subdivision. This is, in our view, a reasonable request, nothing out of the ordinary, and certainly a request that is consistent with the other lots in the area. Looking at this lot, this was created, as you likely know, in 1938 by the plat of Macatawa Park. It's approximately 0.8 acres in size, which is consistent with the size of many of the parcels around it. In fact, there are at least 42 other parcels in the immediate vicinity that are 0.8 acres that have residents improved on them, built on them. In short, this parcel is not demonstratively or materially different than those parcels around it that have been allowed to be developed on. But the Fritzes have been told, unlike their neighbors, that they are not able to build a home on their property because the township, the zoning administrator, has determined that the existing man-made improvements on the site were a mistake or don't provide economic benefit to the property. Therefore, they should be disregarded, not considered for purposes of applying the unimproved lot definition from the ordinance. With respect, we disagree with that interpretation and that application, and that's why we're here tonight. This appeal turns on the application of Section 321 of the Macatawa Park overlay. And as illustrated on the screen in front of you, there are essentially two paths for analyzing a property, C1 or C2. And for purposes of tonight's hearing, we agree with what was stated in the zoning administrator's memo that C2 applies, that's the proper analysis channel for this site because it does not contain a single family residence or another primary dwelling of any kind on it. Now, I would note just briefly and for the record that there is some inconsistency in this section. What I've highlighted there in dark blue are the headings of those sections. Improved lot and unimproved lot. Both of those words, those terms, are defined very specifically by your ordinance in section 38-6. And the definitions of those terms are different than the language that follows them immediately in the other color blue right there. So there is an inconsistency there in labeling it with a heading that says improved or unimproved, and then having the material term language afterwards being different than how those terms are actually defined in your ordinance. But I don't think that that's an issue that the board has to actually resolve tonight. We can move forward with C2 application. The issue that this board does need to resolve is the proper application of one of the subcomponents of C2. And that's the new construction provision. That provision reads, no new principal building shall be constructed on an unimproved or vacant lot unless the lot meets the minimum lot area and minimum lot width of the underlying zoning district. And I've underlined the term that is really at the heart of the discussion today. What does unimproved or vacant lot mean? The ordinance, I would submit to you, already answers that question. In section 38-6, the ordinance defines unimproved lot as a property left undisturbed in a natural state without any man-made feature. That's the definition that has been part of the ordinance for decades. And there is no indication that the use of slightly different language in 321 is intended to create a new standard or a new category that is different than a defined term. Now, in the staff memo, your zoning administrator does advocate for a novel definition, not contained in the definition section of the ordinance. And while I would strongly discourage this board from adopting a novel definition in this case, the definition proposed is not all that different, quite frankly. On page, in the staff memo, I don't remember what page it was, what is proposed is this definition. It's on the last page. A piece of land that has been left undisturbed without use. Those are different words, but it's pretty close to the statutory definition. But here's the important part, is under either of those definitions, lot 52 is not unimproved. And just to clarify something, in the zoning memo to you, the zoning administrator makes a statement that our position is because it's not unimproved, therefore it has to be considered improved. That's not the case. There is some space between those two definitions. We are not advocating that it's an improved lot. If you look at what improved lot is defined in your ordinance, it does not contain a primary structure, et cetera, a building, a residence, and so forth. But lot 15 is not unimproved. The parcel is not in its natural state. It contains a concrete retaining wall. It contains a wood deck. Both of those are man-made. Those are not naturally occurring structures. Both physically exist on the parcel, and both are being used. One to hold up the hill, and the other for walking, accessing a residence, having a picnic, all those types of things. And the staff memo confirms that these man-made improvements are, in fact, on lot 52, the Fritz's property. And they lawfully exist on lot 52. Let me say that again. It's not just that they exist, but they lawfully exist on lot 52. And they have lawfully existed on lot 52 since at least the 1980s. Here's a survey from
Existence since the 1980s.
I believe so. Yes. Here is a survey from 1989 showing how the home and its ancillary structures, the decks and so forth, are spread across 3 parcels, actually, 48, 49, and 52. Now, it sounds like neither we or the township can pinpoint exactly when these improvements were constructed. That's what the staff memo says. But according to our title research, all 3 of these parcels work under common ownership during at least some portion of the 1980s. And that's not surprising, given how this is laid out. It appears that somebody decided this is where I want my house and my pad, if you will, and it was set up. So in 1989, this survey was done, and you can see that there are portions of the improvements that are on lot 52, the green shaded lot. And in 1989, it's our belief this survey was commissioned right at the time where lot 52 was split off, because you can see that right there, they create an easement for it so that it can continue to exist on lot 52, even though lot 52 is being sold off to a different, it can legally be there, even though common ownership has been separated. And in 2015, a restated easement agreement was recorded. This easement agreement incorporates, in fact, the 1989 survey, and it solidifies the continuing basis for the wooden deck and the concrete retaining wall to legally remain on lot 52. It also increases the easement area from 3 feet to 8 feet. Now, I want to address in applying the definition to these improvements, I want to address two statements in the zoning administrator's memo that are offered as reasons why these existing man-made structures should be disregarded. And in our view, those statements are not supported by the text of the ordinance. Here's those two statements from the memo. Now, the ordinance gives a clear, objective definition of what an unimproved lot is. A property left undisturbed in a natural state without any man-made features. The statements from the staff memo introduce concepts like economic benefit, usefulness, intent, or whether something ought to exist where it exists. None of those concepts appear in the definition in the ordinance. Frankly, they don't appear in the definition advocated by the zoning administrator herself. The ordinance does not ask you to weigh the value of an improvement. It doesn't ask you to assess usefulness, and it certainly does not ask you to speculate as to the intent decades after an improvement was constructed. And I'm glad, and I think you would agree, that that is not the exercise that we have to undertake here. The question is much narrower. Has the parcel been left in a natural state without any man-made features? The answer in this case is plainly no. There are man-made improvements physically located and physically present on lot 52. You can go out there and touch them. You can stub your toe on them. You can trip over them if you're not watching where you're going. They exist, they're there. Lot 52 is not an unimproved lot. Now, I want to note, without belaboring the point, and this is not the time for any sort of legal argument on this, but I bring this issue up that interpretation by this board of the ordinance does have broader implications, as I'm sure you guys in township business can appreciate. In light of the other lots of equal or smaller size in the immediate vicinity, I trust you can appreciate how an interpretation that permanently bars the Fritzes from building a home on a long existing, since 1935, and lawfully created parcel could raise some constitutional concerns. That's not an issue for the board tonight, and it certainly is not an argument that we're pressing here. But I guess I'm bringing it up to make this point. As I've explained, the ordinance provides a clear, workable, justifiable, defendable, reasonable interpretation that avoids those concerns entirely. Recognizing the lawfully existing man-made improvements on lot 52 and applying the ordinance as written allows the parcel to be treated consistently with surrounding parcels. And it preserves a useful use for this lot. Unless you have any questions for me, that's all I have.
Are there any questions for the applicant at this time? Okay, thank you.
Thank you.
At this time, I'd like to go ahead and open the public hearing. Is there anyone present who wishes to speak on this matter? Seeing none, I'd like to go ahead and close the public hearing. I just heard one factual thing that I just want to correct for the record. At the beginning of the presentation, I think you said 0.8 acres, but it is 0.08 acres, correct? I know there's a...
Yes.
Yes.
Whatever it is, I'm sorry.
I think maybe you said it both ways, but I just wanted to make sure it was clear for the minutes. Okay, thank you. Okay. Okay, so as we indicated in the introduction and as the applicant has acknowledged, we are here to just decide the appeal of the zoning administrator's decision. We have a copy of the zoning administrator's determination letter. that was included in our packet. The letter dated November 7, 2025. Are there any questions for the zoning administrator at this time? No. Okay. So the applicant has indicated, looking at section 38-321, it's the applicant's position that C1 does not apply, and that C2 is what applies here. That's where the argument is focused.
So, Madam Chair, if there aren't any questions for me, so you guys can discuss freely, I can excuse myself, but I want to make sure everybody's comfortable without questions before I go.
I think that
And do
would
you
be
have-
fine. Just remain accessible in case there are
Yep.
questions that arise.
Will do.
Thank you. Can I have you reapproach the podium? I do have a question. And I'll start by asking you to pronounce your last name for me again.
Gabriel's.
Gabriel's. Okay. Thank you.
I've responded to all kinds of different pronunciations of it too, so don't feel too bad.
Okay, I appreciate that. Thank you. Mr. Gabriel's, section 38-321, sub 1 starts off with the words improved lot, period. Subsection 2, unimproved lot, period, right? And so I think I heard in your presentation that it's the applicant's position that those headings, if you will, for those subsections are inconsistent with the language that follows if we were to look at the general definitions. Is that accurate?
Yes.
Okay. In our packet, and I believe in your application, there is a reference to the zoning ordinance section 38-5 that states, with limited exception, that the headings of a chapter, section, or subsection are for convenience only and not to be considered in construction or interpretation. So is it your, and when I say you, I just refer to the applicant, is it your position that the Zoning Board of Appeals should ignore those headings in deciding this issue before it?
Yes. I think if you read section 38.5 of the ordinance, it says how to interpret headings. Headings are not to add, they're simply for guidance. You have to look at the substantive language. And here, I guess, is the if I can go back to that language that has it. There. If you would apply the heading, in other words, the idea with a defined term is if you say the term, it brings in the whole definition, right? You don't have to state the whole definition every time. You say the term, unimproved lot, and we all know what that means because it's defined in the dictionary at the beginning of the ordinance. If we apply those definitions, like if we would apply the heading, unimproved lot, lot 52 would not fall under section 1 or section 2.
Okay, so you're getting a little bit ahead of where I was going with my question, and I appreciate your comments. If we were to apply 38-5 and essentially strike the headings, then we could draw a line through the part you have highlighted there in the royal blue, right? The improved lot and the unimproved lot. The language that leads into those sections, pardon me while I find it. I believe it states that the word shall is in the lead-in to that section, right? That those provisions, C1 and C2 shall govern. Is that your understanding as well?
Permitted and special uses within the, and this is attached to her memo if you have it, the ordinance, if you were trying to find it.
Yeah, I just wrote it down.
Permitted and special uses shall be regulated in the underlined, subject to the following additional provisions.
Okay, thank
Yep.
you. In subsection C. So yes, permitted and special uses within the overlay district shall be regulated subject to the following. And we know, would you agree that shall is mandatory?
Yes.
Okay. So we are required to apply subsection C1 or C2. Correct?
You need to apply both to any situations that they are applicable to.
Okay.
But that does not mean that everything needs to fall in one or the other, if that's your question. So, for example, let's say C said, like it says, is properties shall be subject to the following restrictions and provisions, okay? And one of those provisions says, if you have a red house, you must cover it on days that the University of Michigan plays football, right? That would be applied, shall be applied, but it doesn't mean that every property has to be subject to that provision.
Okay. I understand that hypothetical. Here, however, subsection C, it shall be regulated subject to the following. And then there are only two options. One, improved lot, but we're striking improved lot for purposes of this conversation. And so it goes on to say, if you're in one, you would be a lot containing a single family dwelling or a two-family dwelling, correct? Those are the only properties that fall under one. Okay.
Correct.
And you agree that one does not apply
Correct.
based on that? Okay. So then the alternative is subsection 2, which starts off unimproved lot, but we're striking unimproved lot for purposes of this conversation. And so to fall under subsection 2, it must be a lot vacant of a principal building, accessory structure, or combination thereof. Correct?
You're asking if you read it correctly?
Well, is that what it says?
I believe so, yeah.
Okay.
Yep.
And we shall apply that language. Do you agree that we shall apply, if you don't fit into subsection 1, which we all, I think you and I are agreeing that that's the case, then you fall into subsection 2, that only applies to, quote, a lot vacant of a principal building, accessory structure, or combination thereof. Do you agree with me on that?
I don't.
Okay, and can you explain that?
And back to my hypothetical about Michigan football, right? Is you can have a provision when it says these shall apply. I mean, there could be 752 provisions that follow that shall.
Okay, so but there are only 2 here, right? So if you don't fit into 1 and you don't fit into 2, then what are you proposing that you fit into?
We could be disagreeing on something that doesn't matter, because I've said I'm fine with C2 applying, because the language of after the heading, a lot vacant of a principal building, accessory structure, or combination thereof shall comply with the following under C2.
Right.
I've acknowledged that. So that does apply. What I respectfully disagree with is that the heading to subsection C does not say all properties within the Macatawa Park District shall fall into one of 2 categories. It does not say that. And I am certain I have seen instances in this ordinance where you have a property that is not subject to, or that certain provisions don't apply to it because of its characteristics, right? And those are still mandatory if you fall under them. If red houses must do something. If you're not a red house, it still is a mandatory provision, but it doesn't mean you have to do anything because you don't meet that criteria.
Okay, so do you agree that a permitted and special use shall be regulated under subsection C? Or is it, are you saying that you should be able to have a permitted or special use in this overlay district regardless of subsection C?
The language of C that you just read is, to me, it's straightforward. In addition to the R4 provisions, which again, not all of the R4 provisions apply to every lot. But in addition to that, the Macatawa Park overlay provisions apply. If the property meets those criteria. And again, I'm saying that C2 applies. So I'm not sure. I'm not saying that there's a third. I'm saying there are certainly properties that would not be improved or unimproved. There's absolutely a category of properties that fall somewhere between improved and unimproved as that definition in the ordinance. But for purposes of tonight and this appeal, I put a green check there on intentionally to very strongly point out that we're agreeing that C2 is the proper subsection for analysis.
So maybe I can ask one more question and then I'll be quiet for a few minutes. But because it sounded like you were asking us to kind of jump over the language in subsection 2 and then really focus on the language in 2A. Because your argument focuses on the general definition of an unimproved lot, correct? Because you're focusing on man-made structures, but the only place we see the man-made structure language is in the general definition of an unimproved lot.
I think I couldn't tell you whether the man-made structure appears elsewhere in your definition.
Sorry,
In the zoning ordinance. I think I understand what you're saying is the definition in 38.6 is what I've referred to, that definition, which brings in left in its natural state without a man-made improvement.
But it would seem that we don't even get there unless you get past the language in 2, which says a lot vacant of a principal building, accessory structure, or combination thereof shall comply with the following. So is it?
May I ask a question or to try to provide some clarity?
Sure.
Does the lot have a principal building?
No.
Does the lot have an accessory structure?
No.
As defined? So because it doesn't have either of those, C2 applies, and then it has to comply with the following: new construction, which now brings back in the definition of unimproved or vacant lot. So I think what you're saying is C2 does apply because of that language. There's no principal structure, there's no accessory structure. But then we look at new construction and it says not just principal or accessory structures, but it brings back in that definition of unimproved lot, which is as you've defined it.
Yeah.
As the zoning ordinance is defined.
Right. If we jump into the pool of C2, C2 does not say no new construction for everything that falls under C2. Right? We're in the C2 pool, we jumped in, and now we apply the provisions. So we look at those provisions. And one of those provisions is the new construction. That applies because we're in the pool, the C2 pool, but we still have to see what it says. And it says, it brings back in the definition from 38.6. So what I'm hearing is us talking about whether it has to be 1 or 2 and me trying to say, maybe not clearly, we are agreeing with this, with the zoning administrator, that we're in C2. So we've all said C2. Now what? Now we go through and apply A, B, C, D, E, F, and G.
So my questions were really geared to try to understand when you were asking us to consider the unimproved lot definition and when you weren't, right? Because I won't go back over it.
Yep.
All right. I will be quiet for a few minutes. Are there other questions for the applicant?
I might have. I obviously was a few minutes late. I'm curious about the history of the piece of property. So this property, was it owned by lot 49 owned and spun off? Who spun the property off this lot? Who allowed 49 to build on it without a variance? You know, I'm questioning the whole, what happened in the first place. How did you get a lot that's so questionable to be built on? I might have missed that history.
We didn't provide anything before you were here.
Oh.
So no, you didn't miss a discussion tonight on that. What I shared in my presentation is what we know about it. That there was common ownership at some point in the 1980s. And the drawing seems to suggest that the property was laid out, you know, and again, as you all know, the lack of ordinances or oversight at some certain time periods in the past, every township or municipality has them. To respond maybe to your question, I would say we wanted to provide that explanation because the staff, zoning administrator had brought it up as far as what's the intent and is this supposed to exist here or not. Our ultimate position, though, is that it doesn't matter. Because the definition of improved property, improved lot, does not say, well, let's go back and look at the history of it. Let's see who built it and if they did that intentionally or whether they were mistaken as to the property line. Let's make a decision. Let's look at whether that improvement economically benefits the parcel or whether it was a benefit to the neighbor. And frankly, there's nothing that prevents any of us from being a pathway for our neighbor or a parking spot for a neighbor. I mean, with other zoning restrictions, right? But we could, out of the goodness of our heart, we could do that. And the point is, the definition doesn't require us to make any of those determinations or ask any of those questions. It says, are there improvements on the property? That, I mean, I think we can all agree there are. And that's our point.
If it was a portion of the neighbor's home that was encroaching as opposed to a deck, would it be your position that there's already a single family home on the property?
I don't know. That's a hypothetical that doesn't exist, and I guess I haven't given it any thought.
Yeah, I guess I could be very ignorant, but why this parcel is allowed to be sold as it is odd to begin with. In my, why anyone would buy a piece of property with this kind of encroachment, this kind of conundrum to it, could be the Park Township's fault for letting it be subdivided in such a way, or a permit for this owner to encroach on the lot, even if they own both lots, but then to allow them to subdivide it and sell it is, I'm just like, historically, this is not a good place.
I mean, if you look at the lots around this Macatow development, and just a joke, Attorney Martin knows this as well, that what they say in Ottawa County is they could lose a judgeship if Macatow Park didn't exist, right? Because there was so much litigation there. There was so many properties that go over lines and so forth. So I don't see this as, I mean, I see this all the time, right? I mean, you do easements, you figure things out, and everybody goes on. I mean, the point, I guess, is this lot, why was it sold? Because it was platted in 1935 and it's existed and it is no smaller than the other lots around there and they will function just fine. They're great vacation homes. Why does this one have to be treated differently?
It's unimproved. I don't know.
Attorney Martin, are you aware of the background as far as it being split or whether there was some indication that the township may have approved a split? I presume the township is not a party to the easement agreement.
That is my understanding, correct. And from what Mr. Gabriel's indicated, it sounds like the three parcels or the three lots, excuse me, 40, even excuse me there, the northern third of lot 48, lot 49 and 52 are at one time under common ownership. The structure was built essentially on lot 49 and then subsequently lot 52 was split off. I think you said in 1989 is when you thought that was based upon the survey. And I was only in college, so I wasn't involved, don't know what was going on at that time. But I think that's where part of the issue would have been, like, why did the township allow that to be split when those three small lots were at one time in common ownership? Mika and I met with Carl earlier, maybe in October or November, and talked about the issue of common ownership. We now have a provision in our ordinance that says these lots, if in common ownership, would have had to been combined and could not have been split.
Right.
But that was not in there in 1989.
But as we sit here today, regardless of the history, we are looking at this lot this parcel as it currently exists.
Correct.
And that's what we are working with.
So you're asking us to allow this building to be built. I'm just, on this piece of property and that's it. They're meeting all the other criteria, basically.
The only question, their application is 3 parts. They would be seeking a variance and other authorizations, as well as appealing from the zoning administrator's decision. We are only here tonight looking at the zoning administrator's decision and the appeal of that decision. So it's not the board's role tonight to say what may or may not be built there, or to address some of the things in the emails that we read about parking, for example. Those are all outside the scope of the item that's before the board tonight. So the question for the board tonight is, does it agree or disagree with the zoning administrator's November 7 letter, in which she states in part, quote, "My determination is that this parcel would be considered an unimproved lot and subject to the regulations found in 38-321-2 of the Park Township zoning ordinance." So we're not here to determine
Thank you.
if something can be built, what can be built, where. It's simply to review that determination of the zoning administrator and render a decision.
If I may, C2A says there's no new principal building on an unimproved lot unless you meet all of the requirements. Mika says it's an unimproved lot. Carl and his clients are saying it actually has a man-made structure on it, so it falls outside of the definition of unimproved lot, but still belongs in C2. C2A, in a sense, in their opinion, doesn't apply.
Yeah.
Because it has actually got an improvement. The retaining wall of the deck in the easement area. And Mika's position is it's an unimproved lot.
So no structure could be built on this unimproved lot.
Correct, unless it met the minimum lot with requirements and it does not.
So tiny, yeah.
Correct. So like that's where it is in a nutshell.
Mhm. And in the eighties, obviously the Park Township or whoever was in control at the time and split these three or allowed that.
The
Thought
township
something could be,
allowed
right,
that lot to be
Yeah.
resplit. And it, like, if you look at the history of that property, it appears for a period of time that it was going through tax sales, like the out of county taxes weren't being paid.
Mhm.
The county treasurer would get it, sell it off in a tax sale, and it kind of went back and forth for a number of years after it was split in
Mhm.
'89.
Yeah.
And it appears that it is being assessed and taxed as a vacant parcel
Mhm.
and has been.
I mean, historically, in good faith, if someone purchased it, they thought they could build something on it, obviously. I mean, if it was allowed at the time. And then sold subsequently for a purpose other than a tent. I mean, what would you do with it? I mean, what, it's kind of silly to have these three lots, all should be one, then they're divided and sold. And then this person who owns it, whoever that may be, historically assumed they would be able to build something, whether it's a garage or, within the, I can understand asking the variance part, we're not responsible for that right now. But the whole idea of the lot and the purpose of buying or selling the lot would be for the purpose of building on it.
Right, if you decide tonight that Mika is correct,
Mhm.
that means the lot is not buildable. You
Mhm.
wouldn't even be looking at variances.
Right.
And then the applicant would have the opportunity to appeal your decision to circuit court if they so chose.
I see what you're saying, yeah. Mhm. What historically has the court said on these sorts of things? Are they all different?
Sometimes the court, in the lot combination requirement,
Mhm.
the court often looks at what Mr. Gabriels is showing here in terms of, well, if you have a lot combination requirement, and you're only requiring two lots to be combined, but you've allowed these less than a tenth of an acre to exist 41 spots throughout this neighborhood, we're not going to require these guys to combine their lot. On the flip side, in terms of the buildability, one, we've got our ordinance, but two, we also have the issue that it's topographically potentially challenging. And so that there might require some state approvals and everything necessary too, which, like, if you, even before you get to the variances or as part of the variances, but right now, what is before you is this an unimproved lot or not for purposes of 321C2A
Mhm.
in terms of having to comply with the minimum lot width requirements?
Yeah, I understand. Thank you. So it becomes basically parkland. I mean, there's nothing you can do with this piece of property. If we make it uninhabitable, basically, it's not, and it's just there.
Well, that's a question
Yeah.
for another day. It sounds like the argument before us is that the property has been improved with man-made structures at this point. So I think that your comments are well received, but they are addressed toward the constitutional arguments that are being made, and I don't think that the board has a jurisdiction to address those tonight.
So there's nothing that says that a deck is a man-made improvement, or, I mean, obviously somebody built it, but like, is there a definition of what
A deck is.
a man-made improvement would be?
There is not a definition of a man-made improvement, but we can, where there is not a specific definition, then the courts would tell us to apply a kind of a common sense understanding of the phrase or of the word.
Madam Chair, given the focus of our scope and what the zoning administrator had to work with in terms of the sections that are applicable, I just feel that you've made the right determination. Any talk above and beyond is not addressing the issue before us. Given what the administrator had in terms of direction and definition, I think she applied her determination correctly.
And so what I'm hearing is it's your opinion that the zoning administrator was correct in determining that this was an unimproved or vacant lot.
Correct.
Are there other thoughts or considerations on that item?
Only the deck, right? That's.
It sounds like a
It's hard
deck
to tell.
and a portion of the retaining wall is how it's
Thank you.
described.
And a retaining wall is not part of any, obviously not a dwelling, so it's just a, thank you.
So we're looking at the definition of an unimproved lot in section 38-6, which states lot unimproved is a property left undisturbed in a natural state without a principal building, accessory structure, or combination thereof, or any other man-made feature. It seems to me in reading the zoning administrator's determination, it was her opinion that these encroachments were not a man-made feature of this parcel, that they were features or improvements to a neighboring parcel that were then encroaching on this parcel. That's how I read her determination.
This is maybe not, when was the deck built?
It
All one lot.
indicating that those improvements existed since the 1980s with an exact date.
Thank you.
You're welcome.
And I just need to ask for clarification if the deck is attached to the house next door, or is it like a separate, like party deck, you know? I'm
Yeah.
not seeing anything that's clearly showing that.
Would you like to speak to that?
That's a question for me.
Sure looks attached.
Yeah, I guess.
The question is whether the deck that's encroaching into lot 52 is attached to the neighbor's home or if it's a freestanding deck, if you know.
Oh, I don't know as far as the construction mechanism, if it's attached to the home or not. It is associated with the home. If that's, I mean, it's around the home. There's the home, and
Do you have your survey drawing that had the three
That's what I
colors?
just-
Maybe that would be helpful.
I don't know if the deck would stay on if it wasn't attached to the house because of the.
I don't know that goes into detail. I mean, on the left side on the 48, you can see a deck. On the right side is also the deck that goes around the house. I'm not a construction GC or anything.
Okay. My question was more in line with, so my personal experience is I live in a similar neighborhood on the other side of the bay. There are people that own property and specifically do not have a home nearby, but they have a deck. So they can put a tent on it, so they can put their lawn chairs, so they can pull their, kayaks up on it. That is a separate thing built for that lot. They can park a camper next to it and step out of their camper. I mean, we have those all over on the lake shore. As opposed to it being accidentally built across to the lot and qualifying as an man-made building. You know what, that's what I was trying to clarify.
I think the zoning ordinance does distinguish between decks and buildings, so we wouldn't consider a deck a building. But it does appear from the drawing in front of us that the deck is not um, it's not an island, that it is, at least if it's not attached to the home, that it is in close proximity to it.
So it's like an accidental kind of over the property line type of a thing. Just like
It was all one, probably
Yeah.
one piece at the time when they built it, the 80s.
It was intentionally constructed in its current location, but when the property was then split,
Mhm.
a portion went with lot 52. For me, it's relevant that the assessor also views this as a vacant lot. That this is not a type of structure or improvement that is assessed to the owner of this property. Because it is an encroachment. It's an encroachment as evidenced by the easement agreement to which the township is not a party. There are just a number of things pointing at this being considered a vacant, unimproved lot. That the zoning ordinance, in my opinion, the way it's drafted, contemplates the improvements be. I agree with the zoning administrator to the extent she's saying to benefit the property. I think that means that those improvements were intended to be on that property to benefit that property. And I think, again, going back to the assessor viewing this as a vacant property, all of those things point to the fact that this, in my opinion, is an unimproved lot. A man-made feature. A feature. It doesn't say a man-made structure, it says feature. A feature is, I think, consistent with what the zoning administrator is saying. A feature of a property, a benefit to the property, something intentionally placed on the property to be a feature of a property as opposed to just existing.
We had our deck done this summer. My curiosity is, are there pilings or things underneath that deck that go in this 52, this lot? How is the deck held on have you guys seen it in person?
I don't think we have evidence in the record to
Okay.
indicate how it was constructed.
That sometimes helps with an idea, if it's down into the property, anchored on the house, or is it just hanging over and could be removed?
Well, it sounds like the applicant is a party to an easement agreement. The property owner is a party to an easement agreement with the neighboring property owner to keep that item there. So therefore, it doesn't sound like there's an intent to remove it at this time, and nothing's been presented to us indicating that it would be removed. Is that accurate?
It's legally, existing where it is. And in that sense, it is permitted to be exactly where it is on lot 52.
Just curious.
And just so that we understand too, when you say that it's legally existing, it doesn't comply with zoning in the sense that it's within the setback. It wasn't approved in that location by the township, but when you say legally existing, it was there when the property was split is essentially what you're saying, and therefore it's currently still existing under the easement agreement.
I have no idea what setbacks were when it was.
Currently, that wouldn't.
So, well, but currently is, I mean, that's not relevant, right? Like whether something is constructed, there's lots of houses there that would not meet zoning if they're constructed now. So whether it's legal, could be that it's grandfathered in and it is absolutely permitted where it is, that there would not be any mechanism for the township to force someone to remove it. And I'm saying, and I don't know that part. What I was talking about in particular was the easement that as between the neighbors, there is an agreement of we will allow you to continue using our property with this deck that's on it.
May I ask a question?
Yes.
Of the 41 structures that are built on lots that are less than 1/10 of an acre in size, do you know when those structures were built? Or
No.
Do you know if they were built prior to this one or subsequent to this one?
No.
I mean, that might be one of the things we would want to look into as well, because this was built on 3 lots. Whereas the other ones were never combined, but still had small cottages, and they could have been built anywhere between 1935 and 1980, 1989. This one came along and the township was, whether by ordinance or practice, requiring the combination of lots. This thing was built clearly with the lots to be combined. They were combined, built over the lot line. I know the setbacks would have had at least a 5-foot side yard setback. Which again, I don't know why the township allowed it to be resplit in 1989, but it's where we're at. But one of the things that you might want to do is table the matter, look into the issue of when the other 41 houses were built on those small, less than 1/10 of an acre properties in the neighborhood. I apologize, Lorna, but I mean, that's something you could probably have staff look into to find out when those structures were built.
Is it your opinion that the history of those other properties may provide insight into the intent behind the township's language that we are looking at tonight?
Not necessarily, maybe, again, I know that what we're looking at tonight is the overlay provisions that Fresh Coast drafted a few years back. I don't even remember, it was pre-COVID. I think it was pre-COVID when we started looking at the various neighborhoods that have unique characteristics like Macatawa Park. And so it might help to, again, understand, because this language is in there about small lots. And historically, small lots had been built on, but they'd all been built on prior to the overlay, generally speaking. But it might help us understand why 321 C2A was put in there. And so some of these, and we can also look to see how many of those encroach onto adjoining properties, whether accessory pieces. I do know the zoning ordinance itself generally provides that you cannot have an accessory building structure without a principal structure. So this is clearly not an accessory to 52, but the deck is an accessory to 49. But when it was built over the line because it was one parcel, no longer, in a sense, 3 lots. The issue isn't whether this is an accessory structure, it's whether it was a man-made feature. But I do think that information might assist us within trying to understand the rationale or purpose behind 321 C2A.
So normally in looking at the intent of the language, we would focus on the language itself and not look at extrinsic evidence of other things unless there's some ambiguity. I don't think that we are here tonight saying that there is an ambiguity, but there is at least an argument being made that the inclusion of the word vacant in C2 along with unimproved may create some ambiguity. That's something that we'll have to resolve with our decision most likely. So I think for that reason, what Attorney Martin is describing in terms of some additional information may be helpful in the board addressing those questions.
If it were if I was looking at it for myself, I would say that deck is part of the house. And that deck is an improvement. And it's not a vacant lot. The house was there. The deck was built on it. It was all one unit. I would personally, if it were, I was looking to buy a property like this, I'd say, oh my, that deck's part of that house. Yeah, I've got an easement, so I can build on it. It's not unimproved. I guess I think it's an improved piece that retaining wall and that deck means that this lot was improved. It isn't a random piece of sand. It was built on. I mean, basically, a deck is a part of a home. At least I think it's viewed that way. And to me, it's been improved. It was all one unit. And the lot was part of, now why it's not our decision, but why the township let that happen in the first place? Not good, but we're the ones that have to pick up the pieces on it. But technically, it's not unimproved. It's had a house, basically a portion of a house on it, with an agreement that this would be an easement on the property when it was sold. I mean, that would be my feeling on it.
And it sounds like the easement agreement was put in place about 36 years after it was split. Okay. All right, so I'm hearing comments as it pertains to improved versus unimproved. There was some expression of a desire or willingness to entertain some additional information to help the board make its decision. Do you think that information would be helpful to the board? Okay. Same.
Yes.
Yeah.
Okay. So I would entertain a motion, if anyone is so inclined, to perhaps table with instructions to staff to provide that additional information regarding historical treatment of parcels in this overlay district.
So moved.
Second.
Okay, we have a motion and a support. Is there any discussion? Okay, could you do a roll call vote, please, Lorna?
Ms. Handel,
Agree.
Mr. Eid,
Yes.
Mr. Cerny,
Yes.
Ms. Payne,
Yes.
and Ms. Morgan.
Yes. Would you anticipate, and I don't want to put you on the spot, but would you anticipate that that would be available for our next meeting, or it remains to be seen?
I don't want to say without consulting Nika just to make sure, but I do believe this is something I could have relatively soon.
Okay, and you'll provide notice to the
Yes.
applicant of when it's going to come back before the board?
Yes.
Okay. Okay. Are there any questions or comments from the applicant regarding what we're doing moving forward?
Is there any information that would be helpful from the applicant?
I'm sorry?
Is there any additional information that would be helpful from the
Oh,
applicant?
from the applicant?
Yes.
Mr. Martin?
I know some of the questions that have been raised, I don't know how material they are, but again, whether there are like footings within the easement area on lot 52 for the deck. I know that was one of the things that Jane had raised.
It's curious.
It may not
Yeah.
ultimately be material, but I know it's something that Jane had asked. I don't know if there was anything else.
I don't think there was anything else specific for the applicant to provide. Yeah, thank you.
Thank you.
Okay, the next item on our agenda is number 5, public comment. Is there anyone present wishing to address the board? Okay, seeing none. Item number 6, our next meeting is scheduled for Monday, February 2nd, 2026, 6:30 p.m. If there's nothing further, I'll entertain a motion to adjourn.
Motion to adjourn.
Okay, we have a motion and support. All in favor?
I
Motion carries. We're adjourned.